So that's 10 past 10 exactly. I'm going to start with a brief introduction as to what we're going to look at here, and it's the statutory provisions and procedure for adverse possession set out in the Land Registration Act 2002, Schedule 6. Paragraph 1, subparagraph 1 provides that a person may apply to the registrar to be registered as the proprietor of a registered estate in land if he has been in adverse possession of the estate for a period of 10 years ending on the date of the application. If the application is objected to, the application will only be successful if firstly the 10 years adverse possession is established and one or more of the three conditions laid down in paragraph 5 are established. Now, we're not concerned with those conditions in detail today. For those of you perhaps in this area, be aware this is where the dealings between the proprietor and the applicant are such that it would be equitable and fair for the applicant based on 10 years adverse possession to become registered as proprietor. Paragraph 6, subparagraph 1 of the schedule provides this, and this is the key part of today's talk. Where a person's application under paragraph 1 is rejected, he may make a further application to be registered as the proprietor of the estate if he is in adverse possession of the estate from the date of the application until the last day of the period of 2 years beginning with the date of its rejection. Paragraph 6, subparagraph 2 provides for 3 instances where a further application may not be made. In short, these are where steps have been or are being taken to obtain possession of the land. And then critically, paragraph 7 provides that if a person makes an application under paragraph 6, he is entitled to be entered in the register as a new proprietor of the estate. So we have the initial application of 10 years adverse possession, but then if that is unsuccessful, we have a further provision of 2 years adverse possession, which, save in specific circumstances, would entitle the applicant to be registered as proprietor. This is the scenario with which I am concerned in this talk. An initial application is made under Schedule 6, paragraph 1. It is dismissed on the basis that the applicant cannot or has not shown that they can establish one or more of the paragraph 5 conditions. The tribunal makes no finding as to the applicant's alleged 10-year adverse possession, notwithstanding that the same was disputed by the title holder. The applicant remains in possession for the 2 years provided for in paragraph 6.1 of the schedule. Question: what does the applicant have to establish on the further application? 10 years adverse possession plus 2 years, or just 2 years adverse possession? Now, before consideration is given to the express wording of paragraphs 6 and 7 of the schedule, the understanding of practitioners was and is that the applicant had been in adverse possession in the land for 10 years or more. The application would be made under paragraph 1. The registered proprietor would object to that application. The application would fail because the applicant, although they were able to show 10 years adverse possession, was unable to satisfy one or more of the paragraph 5 conditions. And provided that adverse possession was maintained for a further 2 years without any steps being taken by the proprietor to terminate the adverse possession, then the applicant would be entitled to be registered. But it was all founded on the fact that the applicant had the initial 10 years adverse possession. This understanding is also set out in the textbooks and also in probably the most important Court of Appeal decision for present purposes in this area, Baxter and Mannion, 2011 EWCA 120. Because what the Court of Appeal there referred to was the gateway to the adverse possession statutory scheme being the 10 years or more adverse possession prescribed by paragraph 1 of the schedule. Well, that was the understanding and expectation, but that appears not to have got through to whoever was drafting the schedule, because however is drafted, paragraph 6 and 7 of the schedule permit of an applicant whose application was rejected for any reason, so that would include an applicant who was unable to satisfy the 10 years adverse possession period laid down in paragraph 1, to become registered proprietor of the title and to the property, provided that after their initial application was dismissed, they could at least show 2 years adverse possession. The result of this being a title could be established on the basis of only 2 years adverse possession. I just remind you of the wording under paragraph 6.1 and where this comes from. It's this: where a person's application under paragraph 1 is rejected, nothing else. A person's application under paragraph 1 could be rejected because they didn't show the necessary 10 years adverse possession. On the one hand, to us seasoned property practitioners who've grown up with adverse possession prior to and post the statute, this could appear irrational. For example, an applicant with a weak case to establish a 10-year period of adverse possession under paragraph 1 could allow the application to be struck out for procedural reasons and rely on the proprietor not taking any steps to obtain possession following the striking out, and make a further application based only on 2 years adverse possession. That appears ridiculous. On the other hand, it could be said to be consistent with the policy behind the schedule, that of enabling registered proprietors, save in exceptional cases, of having notice of an attempt to obtain proprietorship via adverse possession, and being able to defeat the same through taking steps to vindicate its rights of proprietorship. The registered proprietor is heavily protected at the initial application stage. The conditions limit successful applications to those where dealings between proprietor and applicant are such that fairness dictates that the applicant becomes proprietor. If the proprietor is successful at the initial stage, then the position set out in schedule at paragraph 6.2 makes clear the steps that they should take to bring to an end the applicant's possession and prevent the applicant being able to make a further application. If the proprietor does not do this, then it has, quote, slept on its rights, end quote, something that the schedule was designed to discourage and sanction, and therefore it is only itself to blame if it loses a possession title to the property based on a minimal period of adverse possession. This issue has been considered, albeit briefly, in the case of Gill and McCarthy, 2016 tribunal case. It's implicit in this decision that the further application can only be engaged where the initial application established 10 years adverse possession for the purposes of paragraph 1, but failed to establish one or more of the conditions. On the basis of this authority, which in terms of outcome is consistent with practitioners' understanding, the further application could not be made because the initial applications did not establish 10 years adverse possession. So in the examples we posed, if the applicant at the first stage failed to establish the 10 years adverse possession, then a further application was not open to them. Whilst the sentiment and outcome behind whilst the sentiment behind the decision is consistent with understanding, the reasoning for the same, in my opinion, does not stand up to scrutiny. In particular, it does not engage with the wording of the schedule, which does not obviously permit of a limitation on the circumstances in which a further application can be made, say for the 2-year period. It also does not deal with a situation where, as in the cases we're considering in this talk, there is no finding on the initial application as to the issue adverse possession for the purposes of paragraph 1. In my opinion, I would not expect the decision to be followed, and this appears to accord with the views of other practitioners who have written on this issue. So it's all right disagreeing with it. What's my position on it? Well, here we go. In my opinion, the answer to the issue lies in the approach adopted by the Court of Appeal in Baxter and Mannion. The precondition to any application under the schedule is adverse possession of an estate for a period of 10 years. And to quote from the Court of Appeal, that surely indicates that a person who has not in fact been in adverse possession is simply not entitled to apply. Parliament cannot have intended that such a person could get a registered title. Bearing in mind that an application under paragraph 6 is further to an application under paragraph 1, it must follow that it can only be made by an applicant who has been in adverse possession for the minimum 12-year period, being the 10 years prescribed by paragraph 1 and the further 2 years prescribed by paragraph 6. If there has been a finding on the initial application that there was 10 years adverse possession for the purposes of paragraph 1, then the further application is straightforward and the applicant will be registered provided that paragraph 6.2 is not engaged, i.e. no steps have been or are being taken to take possession. If there has been a finding on the initial application, then there was not 10 years adverse possession for the purposes of paragraph 1. Then, although this results in the rejection of the initial application, as referenced in paragraph 6 of the schedule, no further application can be made. The difficulty comes with this. If there has been a rejection of the initial application, but no finding as to adverse possession, a further application can be made, but on such application, the applicants would need to establish the adverse possession prescribed by paragraphs 1 and paragraph 6. Pausing there, Schedule 6 does not easily permit of an inquiry as to 10 and 2 years adverse possession on the further application. If therefore you are for applicant or proprietor, then you are going to need to be aware of this vagary and make sure at the time that the further application is made, that you are either engaging with your opposite number to identify this as an issue and that this needs resolved, or if agreement cannot be reached there, engaging and referring to the tribunal to make sure that this issue is determined. This position could be avoided if on any initial application, the tribunal, where it has heard the evidence of the 10-year adverse possession, is requested to make findings as to whether or not the adverse possession is made out. In the last year, I think I've seen 4 or 5 cases where under the initial application has been dismissed because the tribunal concluded, well, I can deal with this quite straightforwardly because it's quite clear, I'm satisfied on the evidence that the conditions aren't established. Well, that is fine, but they have to have an ear and an eye to the further next stage, and the fact that they are in the best position to take a view as to whether or not the 10 years adverse possession has been established. And if you're acting in such a case, you should be directing the tribunal that it should, as part of fulfilment of its judicial function, make a determination of that issue, and you can point out the very issues which will be relevant, because otherwise you'll be having a duplication of time and cost and another judge being called upon to try it at the further application stage. I have surprised myself, which is unusual, counsel. I've gone through that much quicker than I thought I would. As I said at the beginning, there is a copy of this handout to be available. If you want to request that via email, either to Chambers or to myself, please do so. Also, as Nigel said, I'm happy to take questions via email on this interesting area. We're going to keep the link open because I don't think anyone needs to practice with slides. The next speaker is going to be Matthew Hall on mines and minerals, and I understand his talk will start at 10:45. So I hope you'll appreciate the fact I've given you a lovely mid-morning break to go and get a coffee or a tea or what other beverage suits you at this time of the morning. And thank you very much for listening, and enjoy the rest of the seminar. Thank you and good morning.